New to Florida? Get ready to get lawyered up and dive deep into the legal realm of personal injury law with Martin Hernandez. Brought to you by myself, Martin Hernandez, the fearless advocate fighting for justice in the Sunshine State. We're here to uncover the truth, debunk the myths, and deliver the legal insights you need. From car accidents to slip and falls, we've got you covered. So buckle up and hold on tight because we're about to take you on a wild ride with What the Florida when it comes to personal injury law. With us today is Don Christopher Alfonso of D. Christopher Alfonso, PL. Chris has been an estate planning lawyer and estate planning asset protection lawyer since 2004. So for the last 19 years, he's been here protecting us from taxes and asset collections and making sure that our estates are properly planned. Chris, where'd you go to law school?
Martin, thanks for having me. I've been a loyal tenant and good friend of Martin's for quite some time. So.
Yeah, actually, we met in grade school. We didn't hang out there, but we also went to Jesuit together. And then you went to law school. Where did you go to law school?
So I went to the University of Florida first for undergrad.
All right, go Gators.
Had such a good time there that I had to go out of state for law school and ended up at what we affectionately know as the E.J. Salcinas College of Law, which is South Texas College of Law in Houston, Texas. Went there for a couple of years and then got back into the state of Florida and went to the University of Florida for my last year of law school. So did that, did some master's work in graduate tax, and that's kind of where I developed my interest in trust and estates.
Because when it comes to estate planning, taxes is a big consideration, right?
It's a huge consideration. The environment right now is a little different than it was when I first came out. There are a lot of other things that go into an estate plan, but you're always considering taxes, especially for a married couple. So that's one of the first things I look at when we meet with clients, especially a husband and a wife or two spouses. We look to see what their tax situation is.
And how to either delay, avoid, or all around not paying taxes, right? Or minimize the taxes.
We never say not pay taxes, Martin.
Well, okay. It's minimize taxes. And I'm not suggesting tax evasion. I'm saying tax avoidance. There's a difference.
So we try to make our clients pay as little taxes as are allowed under the law.
Okay, that's what I like to hear.
That's what our goal is.
Okay, all right. Well, let me ask you this. What legal considerations should an estate planning lawyer keep in mind? Let's say husband and wife married 40 years, or even 25 years. What should they be looking at?
So I'm looking at the length of marriage. That's probably the most important thing that I look for is how long has the couple been married? Do they have children from the same marriage? If they answer yes to those first two questions, that makes my job a lot easier because then I can focus and tailor their plan to those specific needs. If they tell me they have a blended family or they're on their second marriage, third marriage, or more, then we need to alter things a little bit, and or if they're not married at all, then that also is a consideration for what we're going to do.
Okay, so basically, if I have a girlfriend, a common law girlfriend, which there's no such thing in Florida, but let's just say a girlfriend, she and I live together, have a house together, but we're not legally married. Mm-hmm. You treat that separately, but we have children together. You're saying we treat that separately or differently than a wife?
We would,
all right,
for sure.
She has to be written into the will?
Yes. So you definitely want to have some type of document, whether it's a will or a trust, that specifically names that person as a beneficiary. But if they want to bypass their significant other in that situation and direct things to their descendants, their children, their grandchildren, or something like that, we have to warn them ahead of time if they do get married, or if their marriage does get recognized in another jurisdiction, then there's some agreements and waivers we need to put into place in order to do that.
Okay, but let me ask you this. If I'm legally married, can I write my will and not include my wife?
You cannot.
Oh, so I cannot write her out.
You cannot. That is a dangerous thing to do under Florida law. In theory, you could, but it's going to bite you later on when you're going through an administration process. So if a client comes in and they're married and they want to do something like that, then we stop right there and we discuss waivers and marital agreements and property agreements to make sure we dot our I's and cross our T's to make sure that that process goes as smoothly as we possibly can.
Can the spouse sign off saying, hey, yeah, I understand I'm going to be excluded from this estate, and sign off on it and proceed from there?
That would be a spousal waiver, and yes, we do that. And that is one thing that I require up front in order to do that type of planning. A spousal waiver of their homestead rights, the right to something called an elective share under the estate, and a few other rights that a surviving spouse has in an estate. All those things need to be waived up front, and it needs to be done with full financial disclosure.
Okay, so the spouse has to understand, hey, listen, this is what I'm giving up.
Exactly.
All right. What if I have a delinquent kid or some knucklehead kid that I just don't want to give him anything? Can I write him out or her?
You can do that as well. You need to be very specific in your documents, in your trust or your will, that you're not intentionally providing for an existing child. Otherwise, that can bite you too later on.
How about, do you put like a catch-all phrase in your wills and estates, or in your wills and trusts, that says let's say I was a playboy before I got married and had some fun, do you put a catch-all phrase saying all unknown?
Yes. So we take care of the Playboy Mansion situation.
All right.
So.
That's what I was thinking of. All right. Chris, now I'm going to give an example of the importance of updating your estate.
Sure.
And about 15 years ago, I represented a police officer who was driving his motorcycle down, US 41 in Pasco County, and a Pasco County employee turned left, violated his right of way, and unfortunately killed him. There were some circumstances behind that case that there was no specific personal representative. He had remarried. The prior will had the personal representative was the first wife, and he had an insurance policy that stated her first wife as the beneficiary because he had children with her. Now, after his passing, the wife was a very good person, and she actually used that money to actually raise the kids. But how important is it to renew or update your estate planning?
Well, Martin, I wish I was in your office at that time. I would have made sure that situation did not occur. Unfortunately, it happens a lot. So you have spouses with the best of intentions, and they name their surviving spouse as the beneficiary on a lot of different documents. Then they get divorced, and they don't update their documents. The law was changed a few years ago to sort of correct those situations. The law sort of presumes now that, hey, if I get divorced, then maybe that beneficiary designation on my life insurance policy shouldn't be my former spouse, and then I should just treat the backup beneficiary, which normally would be your children, as the primary.
Right.
But there's situations that are unique. Maybe you want to keep the former spouse on there as the beneficiary.
Should you put down maybe that the beneficiary should be your estate, if you have one?
I don't mind putting the estate down there as a beneficiary. Just remember, if you name the estate as a beneficiary of life insurance, it's going to go through a probate process, which is a court-administered administration. And most of the time, the folks that I represent don't like probate. So
probate costs money.
It costs money. It's tedious. It's time-consuming. It's generally a process you don't want to go through.
Where should your life insurance go to?
Ideally, you want your life insurance to go to specific family members, number one. You want to make sure that it's an intended beneficiary. So after you get a divorce, you want to make sure that you clean up who those beneficiary designees are, number one. Number two, you want to look at your tax situation. It may not always be right to name a specific beneficiary, or it may not be right to name the estate as a beneficiary, because it means that the value of the death benefit is going to be included in your estate. So those are all questions for an estate planning attorney. I answer them a lot. Sometimes we'll put those life insurance benefits into a trust.
All right, that's what I was going at, because in my experience, handling auto accidents, a lot of times I represent young adults, 18, 19, 20, 21, 25, and they get a big lump sum.
Correct.
And in my experience with auto accidents, and my understanding of the statistics are that if you have an auto accident and you get a big chunk of change, or you win the lottery, or you inherit money. Within 2 years, you've blown through the money, and actually the statistics support that.
Sure.
Within 2 years, you blow through the money, and you're back to where you were 2 years ago, or worse, because now you've overextended yourself. So I always recommend to young adults and to parents not to give the kids a whole lot of money when they're young. Do you agree with that?
I do, and it's a great segue into a case that we were involved in a few years ago in Polk County. Sometimes you don't want it to go to a certain individual.
Right.
Not only that, but you may have a client who may not handle money the right way. In those situations, putting it into a trust, having a trustee that manages the money, provides the asset protection that person vitally needs. And
from themselves
and from others, absolutely. And we've done a few of those, and
yep, we have.
That is one of the great reasons why trust and estates kind of is a good fit for what you do, because you and I deal with a lot of the same issues regarding settlements and what happens when a chunk of change gets into the hands of a client and they need help managing it. It goes beyond just settling a lawsuit. You need to have a trust and estates lawyer that can advise on where that money should go.
Yeah, and how it should go.
And how it should go, precisely.
Right. You don't want to give them $10 million right now, because you're going to be in a much higher tax bracket versus, hey, we're going to give you $20,000 a month for the rest of your life.
I had a professor in law school that says, what happens when they get their hot little hands on the money? And a lot of times it's not good.
No. And again, they get back to broke within 2 years, or in a worse position because they've overextended themselves.
And I give these clients a lot of credit for saying, hey, I don't need to have $10 million in my hands at this moment. I need some help managing it. So credit to them for seeking, our advice to do that.
Yeah, I agree with that. And let me ask you, are there any legal risks associated in not hiring a qualified estate planning attorney?
Yeah, you can screw up your own estate plan. I see it all the time now with LegalZoom and these.
I was just going to say that those online, almost one size fits all. Good idea or bad?
Horrible idea. I make this promise to my potential clients. If they want to save some money, I'll say, look, you go online, you do the LegalZoom, then come and see me and let me review it, and I'll give you every reason why what you did online is wrong or is not in your best interests. And then tell me who ends up spending the most money when you're done.
Yeah, well, I always say, you think doing it right is expensive. Wait till you do it wrong.
Exactly.
And hiring a qualified lawyer is not cheap, but doing it wrong is a lot more expensive.
It sure is.
Let me ask you, how can estate planning attorneys protect their clients? Besides, let's say, for example, a durable power of attorney. What is that, and how can you protect your clients with that?
So clients come in thinking that the most important thing they do is a last will and testament or a trust agreement or something like that, and they're concerned initially about what's going to happen when they pass away. And I tell them, the most important thing you should be concerned about is what should happen if you become incapacitated.
Right, because I actually read some statistics on that a 35-year-old male is 10 times more likely to become disabled than die. So that's really important.
So it is vitally important that they come in and we plan for their incapacity. And the only way to do that through an estate planning process is through a durable power of attorney and advanced healthcare directives. Both of those name people in those documents that will take care of them in situations where they're unable to take care of themselves, or in situations where they may want assistance in taking care of themselves immediately. So we put together the powers of attorney both financially and medically, and those are a tremendous help in situations where, further down the road, they're unable to manage their own financial affairs or make medical decisions, and they avoid the guardianship process, which is a nightmare.
So basically, dad's coming down with dementia, but before he goes into dementia, he lists a couple people to work on his behalf. That's when it can kick in.
Absolutely. So we'll have them sit down, and we usually want to have a close family member as a primary, and then we'll name one or two different backups that are either family members or close individuals that are local.
Yeah, I was just going to say local because, if one kid lives in Hong Kong and the other one lives in Atlanta, but you're in Tampa.
Does you no good.
Yeah.
From a practical point of view, it does you absolutely no good.
Geographically undesirable.
Absolutely. But I can tell you nightmares about the guardianship administration process. It's court administered, similar to probate, but a lot more scrutiny. So everything is audited when you file something in a guardianship each year. And from personal experience, it's a rough process, and it's an emotional process for your clients who see loved ones have to go through a guardianship, and they don't understand why, there's so much scrutiny from the courts.
Right. And I actually tell people all the time, you want your kids to fight after you pass away, don't write it down. Don't tell people what you want, what your plans are, because then one kid's going to try to fight for the other one, fight for his behalf. No, I should talk on mom's behalf. Or, no, I should talk for mom's behalf, blah, blah, blah. Is that what you find out?
So that leads into another interesting segue. Clients are surprised when I try to limit the amount of copies of documents I give to them. I always try to keep the original stored in a safe place in my office. I'll give one copy to clients and sometimes two, but you really want to limit the dissemination of paperwork. You really want to keep your estate plans close to the vest, because you don't want to have situations where you have competing family members arguing over your estate plan until they absolutely have to know what's in it. I think privacy is paramount.
Especially if one child's getting more than the other, I guess.
Exactly, yeah.
Or, hey, I wanted that, 1967 Camaro. Why are you getting it?
Yeah, or, that was my baseball card collection. Why is that going to, Cousin Joey? Or why wasn't I named the personal representative of my estate? So,
what if one of your kids is a felon? Can he be the PR?
It cannot be the PR, and that's always a dicey question I ask at the very beginning. But they cannot be a PR if they've committed any sort of felony or they've had a crime of moral turpitude. There's a few other factors we kind of go over, but they cannot serve as a PR and they cannot serve as the guardian of an estate during a guardianship administration.
Forever? Because, what if it was 40 years ago?
Forever. No leniency on that one.
Let me ask you, Chris, what steps should a potential client take before they come and see you?
Well, I think half my battle is getting them through the front door. And I've tried to give them intake information to fill out beforehand. I generally find it's best just to get them through the front door and have us go through the intake and the biographical information in person together.
So you get basically a flavor of what their personal situation is before you just have them fill out a questionnaire?
I try to in the initial conversation over the phone. I can generally figure out in the initial conversation over the phone where we're heading and where we're steering our estate planning. But actually sitting down for 30 minutes to an hour with a client, we sort of run through scenarios that I can't do if they're just doing it ahead of time. So they may not be sure when they first meet me who they want to name as their trustee or their personal representative or their agents or their powers of attorney. But just having that conversation with me, I can sort of steer them in the right direction. And I generally find that's a more favorable outcome if they do that way.
Okay. Let me ask you, can you sometimes bypass your kids and go right to the grandkids? If, let's say, your kids are all well-to-do and you want to leave a legacy behind. Good idea, bad idea?
In my opinion, there's different philosophies on this. I try to do a very simplified estate plan because it's something that, my clients can understand, number one. And number two, it's a much more efficient way of transferring assets. I generally recommend against doing that. There's tax implications for skipping generations, and there's additional paperwork that needs to be done if you're going to skip generations.
So if, let's say, I'm raising my grandchild and she's 18, I want to avoid a lot of problems and a lot of taxes, maybe it's not a bad idea for me to adopt my grandchild, even if they're an adult?
I wouldn't say adopt the grandchild. If they absolutely have to leave something to the grandchild, we definitely would want to do it through a trustee and in a trust.
All right.
But we definitely want to explain the ramifications of doing that and the generation skipping transfer tax ramifications and filing the exemptions and doing all that. So if they absolutely have to leave an inheritance to a grandchild, as long as it's explained correctly, I don't mind doing that. But if there's a choice between skipping a generation versus leaving it naturally to a descendant and letting it flow down, I would rather pick the latter option.
All right. The lesser of two evils?
Lesser of two evils, yes.
Chris, you also handle a lot of land trusts. I think we're about wrapping up pretty soon, but briefly, what's a land trust?
So land trusts are basically ways that you can acquire real estate and maintain confidentiality. It was started in Illinois. We recognize it here in Florida. It's actually how Walt Disney acquired all his land in Central Florida to basically put together the Magic Kingdom back in the 1960s, because he had to buy a lot of parcels of land and he didn't want anybody to know about it because it would drive up the price of the land, right?
Which is what happened in Disneyland in California. All the hotel chains said, hey, you're building Disney right there. Let's go and buy all the land. And that's why it's so much smaller.
So a lot of real estate investors know about land trusts, but the regular common folk clients don't realize that they could use it too if they want to purchase real estate, a piece of property, an investment property, and maintain confidentiality. And they're very easy to set up. For a lot of the stuff that I do, they're not particularly cost prohibitive. They're pretty inexpensive to do, and it's a great part of the asset protection that we can do for folks that are buying real estate. So I wish more clients would come to me knowing about land trusts.
I was just going to say the same thing, because nosy neighbors next door won't be looking you up and seeing that you own 5-10 pieces of property.
Exactly. And the other thing I see is some folks will go to Barnes & Noble and they'll pick up the land trust book that's out there. It's a great book, but they'll mess it up if they do it on their own.
Again, doing it right is...
Got to do it right, and you got to have the land trust set up before you purchase the property, because you want to go to closing in the name of the land trust.
Well, thank you again, Chris. This is Attorney Martin Hernandez, and wrapping up the New to Florida, and get ready to get lawyered up now and dive deep into the legal realm of personal injury podcast. Brought to you by myself, Martin Hernandez, the fearless advocate fighting for justice in the Sunshine State. We're here to uncover the truth, debunk the myths, and deliver the legal insights you need. From car accidents to slip and falls, we've got you covered. So buckle up and hold on tight, because we're about to take you on a wild ride with What the Florida when it comes to personal injury law. Chris, can you give out your information in case any clients want to contact you to do some estate planning?
Well, first of all, thanks for having me, Martin. It's been a pleasure to be here.
Thank you for coming.
Like I said, there's a lot of tie-ins between what I do and what you do. And if folks want to reach me, they can reach me at my website, which is wealthplanninglaw.com. Again, that's wealthplanninglaw.com.
Thank you, Chris.